our last media briefing for 2019. We have already had 3 media briefings for the financial year 1920. So this will be the last, in fact the last one will be the first quarter of 2020. We have the power as regulated by the national legislation to investigate, report on and remedy any improper or prejudicial conduct in state affairs. This particular briefing, during which I will issue findings involving 24 reports, is special in that it coincides with the departure of Advocate Malunga as my deputy and the anticipated arrival of his successor in title. We bade farewell to Advocate Malunga on Tuesday. We wish him all the best in his future endeavors. In the same breath, I wish to say on behalf of the staff that we are ready to welcome whoever will be appointed the new Deputy Public Protector. I was saying last week to a radio station in Northwest during our roadshow that sometimes it looks easy when you are on the outside looking in, and in fact from the outside looking in. It is only when you are on the inside, in the thick of things, that you will realize that this work is not the proverbial bed of roses. I trust that whoever makes the cut has a thick skin, because they will definitely need it to withstand all that is coming our way. This briefing also presents me an opportunity to look back with the staff of Public Protector South Africa to reflect on the year that was. It was 12 months. It was a 12-month period during which we recorded major wins, but it was also a period during which we experienced a minor setback. This is the year during which we received a positive feedback from the Auditor General, our sister organization, on our audit outcomes and financial performance for the 2018-2019 financial year. We got an unqualified audit opinion and reduced our irregular expenditure by 16 million, while incurring no new irregularities in the expenditure. When it comes to the core function, our overall performance shot up from 50% achievement of the set targets in the 2017-18 to 72% in 2018-2019. We've issued 46 reports instead of 30 investigation reports, and we also have finalized 99% of our workload during the time frame. 77% of cases older than 2 years were also finalized, and all in all, just under 10,000 out of the caseload of 14,000 complaints which were finalized. The impact we made this year on the lives of the people at the grassroots can be seen in several of our investigation reports, such as the one we've issued on Toyota Quantum panel vans that are illegally converted into passenger-carrying minibuses. There was a groundswell of praise among key stakeholders for this report. For instance, the complainant, Mr. De Beer, who has pursued this matter since 2012, wrote an emotional email to us thanking the office for intervening on the plight of the commuters and as well the minibus taxi owners. In addition, Santaco President also and the then Minister of Transport, Mr. Nzimande, welcomed the findings and the remedial actions, and they are implementing the remedial actions as we speak. By now, you should be aware that the bulk of our investigations do not result in formal reports. We gather evidence and then sit with the parties around the table to broker a settlement. Some of these rank highly on my list of this office's most impactful intervention this year. They include cases of a retired disabled police officer who got 41 years worth of pension benefits within a month of raising the matter with my office. Again, it also includes the story of a 98-year-old indigent granny from Limpopo in Musina local municipality whose water was cut off by the municipality when somebody else tampered with her meter. And she was also alleged to be owing 13,000 rands, which at a later stage, through the intervention of our Limpopo Provincial Office, that was written off. All this show that we are on course to fully implement the Public Protector Vision 2023, which is about broadening access to the services of this institution. This vision focuses on being accessible to the people, enhancing this access by engaging communities in their mother tongue and increasing the institutional footprint to complement our 19 offices which we have across the country. Through Vision 2023, we also look at leveraging stakeholder relations in advancing our interests through the MOUs such as those we have entered into with the Department of Justice, especially we would want to utilize their magistrates' court offices, the tax ombudsman. We've had, or I've said several times as well, that there's a lot of complaints which are now processed by the tax ombudsman, which would have been brought to the public protector, the provincial speakers whose role is oversight over the executive, but also they receive complaints through the petitions process. Therefore, the MOU helps us to eradicate duplication of the work between the two. The Public Service Commission, the South African Human Rights Commission, the Health Ombudsman. So those are among of those institutions we've entered into the memorandum of understanding. Therefore, I would also want to mention that we are still continuing to encourage various state organs to establish in-house complaints handling mechanisms, and so that as an institution we can focus on systemic investigations. We also don't do the work of the public servants, but also encourage the public to be their own liberators, also to engage the various public servants, and also not engage in violent protests, but then also the public servants to be responsive to them. It was, of course, not all smooth sailing. The lowest was, for me, the Constitutional Court judgment on personal costs. While we respect the courts and their decisions, it remains my considered view that that decision is a threat to the independence of this office and sets a wrong precedence which will have a negative impact on my work and future public protectors. Again, I need to indicate that it's also a concern for the African Ombudsman and Mediators Association and International Institute for Ombudsman, which is an international organization as well. We hope for a better experience in 2020, and as I've said several times, that we find solace in the minority judgment, which has properly captured our papers. I now turn to the main business of the day. The reports I'm issuing covers various themes that are of great concerns to me. Before I reveal the findings, I must indicate that a number of frequently asked investigations are at an advanced stage, and reports in some of these cases are imminent. The matters in question include the Friede Integrated Dairy Project, the VBS matter, in which our focus is on the conduct of actors within various municipalities who deposited municipal funds in the mutual bank, since we do not have jurisdiction over the VBS as a bank. There is also a pending investigation on the role of the South African Reserve Bank in the whole VBS saga. We are experiencing challenges with this one because South African Reserve Bank seems to believe that we do not have jurisdiction over it. They seem to have misinterpreted the Constitutional Court judgment on personal costs. Also in the pipeline are the Free State website matter, the South African Revenue Services and Makwakwa matter, Kusile and Midupi power stations matter, the Independent Power Producers matter, the Guyana Water Project matter, and the alleged irregular procurement of services by SARS from a company known as BBND. This brings me to the focus of this briefing. I wish to start with the investigations that we have closed on the grounds that the allegations that triggered them were all unsubstantiated as part of our efforts to clear the backlog. These are the cases dating 2 years and back. Others are even more than 5 years. We have prepared closing reports to mark the end of these matters. These reports, like all others, will be available on our website so people can read for themselves and understand the rationale for us to close these matters. The matters relates to allegations of improper receipt of bribery by Ms. Balekambete in the form of share allocation amounting to approximately 25 million in Invictus Gold Limited, as well as the role played by the Department of Mineral Resources in 2010 in the 2010 broad-based black economic empowerment concluded with Goldfields Limited. So this matter has been closed. Allegations of a breach of an executive member's ethics code by former Minister of Communications, Ms. Faith Mutambi, in connection with the SABC inquiry. Allegations of maladministration and improper failure by the Department of Military Veterans to provide statutory benefits to Mr. Qindi. Allegations of maladministration with regard to the appointment of Lieutenant General Solomon Makhale and 2 other major generals without following prescribed procedures by the former National Police Commissioner General Ria Pierga. Allegations of conduct failure by the former Minister of Energy, Ms. Jumat Peterson, concerning the nuclear build program, as well as procurement irregularities in connection with the procurement of an integrated information governance administration by the Council for Medical Schemes relating to alleged failure by the CMS to regulate and oversee the merger between Medicover and Liberty Health Medischeme. Allegations of improper conduct and maladministration within ESCOM. This was in connection with allegations that ESCOM used a concept invented by the complainant to develop a program called Operation Khanyisa without acknowledging her as the source and creator of the concept. Allegation of abuse of power and unjustifiable spending by the City of Johannesburg. This was a complaint lodged by former Mayor Herman Mashaba, who alleged abuse of power and unjustifiable advertising spending and wasteful and fruitless expenditure relating to non-compliance with the Municipal Finance Management Act against the city. I now move to my findings on various matters which we've concluded this quarter. On pension matters, there's the matter of Filifani versus Correctional Services. I investigated allegations of improper conduct and maladministration by the Department of Correctional Services. This related to a non-payment of pension benefits to a deceased employee's family, Mr. Filifani's next of kin. The complaint was lodged in 2017 by the mother of Filifani. Upon analyzing the complaint, I decided to focus the investigation on 2 issues only. The first was whether the department informed the government administration agency that the complainant was the nominated beneficiary of the pay benefits of the deceased. The second was, if the above was not the case, was the failure by the department to inform the JIPA improper, and did it constitute maladministration, and did it prejudice the complainant. I found both allegations to have been substantiated, and the failure by the department constitute improper conduct as envisaged in the Constitution and maladministration as envisaged in the Public Protector Act. To remedy the improper conduct and maladministration, I directed the National Commissioner of Correctional Services to determine, with the assistance of JIPA, the amount and interest that the complainant is entitled to as nominated beneficiary of the pension benefits of her late son when he passed on in May 2009. The commissioner must also calculate the interest which must be paid, and he must also issue a letter of apology to the complainant. The next matter relates to Sihale versus Mpumalanga Department of Education. I investigated the allegations with the assistance of the Mpumalanga Provincial Office, where the Department of Mpumalanga failed to submit Ms. Sihale's personal file of employment records to the Gauteng Department of Education when she was transferred in December 1992. As a result, she was not paid her pension benefits for the period 1978 to 1992 when she retired in December 2014. Based on the complaint, I decided to look into three issues. Firstly, I investigated whether Mpumalanga Department of Education delayed to transfer the complainant's personal file or employment records to its Gauteng counterpart when she was transferred in 1992. Secondly, I investigated whether the Mpumalanga Department of Education failed to properly manage and to take care of the employment records of the complainant, and if so, whether this amounted to maladministration. Lastly, I investigated whether the complainant was improperly prejudiced by the conduct of Mpumalanga Department of Education in the circumstances. I found all the allegations substantiated, and the Department of Education in Gauteng requested the employment records of the complainant in 1995 from the Mpumalanga counterpart, but then there's no evidence that the records were shared. So during the subpoena hearing in April 2019, the Mpumalanga Department of Education confirmed or remarked that their records are not, or their filing system was in a state of disarray. This has then led to the non-response, which is maladministration, which is also violating the Constitution. Section 237 of the Constitution, which provides that all constitutional obligations must be performed diligently and without delay. As part of the remedial action, I directed the acting Mpumalanga Department of Education to issue a written apology to the complainant, expressing remorse for his department's undue delay to submit the complainant's personal file to the Gauteng Department of Education when the complainant was transferred. This must happen within 14 working days, and the acting HOD must ensure that the Mpumalanga Department of Education pays interest in terms of the prescribed rate of interest Act 1975 on the amount which will be determined by the GPA after recalculation of the complainant's pension. And the next complaint relates to RDP housing matters. There's one complaint which was lodged, which we investigated, allegations of maladministration. This is Mahlangu versus the City of Tshwane. Maladministration and improper conduct by the City of Tshwane Metropolitan Municipality and the Gauteng Department of Human Settlement by allocating an RDP house that was approved for Mr. Simpiwe Mahlangu to another person. Mr. Mahlangu, who lodged the complaint in April 2018, alleged that during the year 2000 his name was approved in order to be allocated an RDP house and in Mamelodi Extension 17. However, the house was never allocated to him but to another person, Mr. Modise, who was at the time occupying the property. I investigated whether the city and the department improperly allocated the house which was already allocated to Mr. Mahlangu, and whether Mr. Mahlangu suffered prejudice. After careful examination of the evidence during the investigation and the regulatory framework, since we check what regulatory framework has been violated, I found that both allegations are substantiated. As a remedy, I directed the city to submit a formal request to the department in order to transfer the complainant's subsidy approval on this stand in Mamelodi to the new service stand project in ESDRS, because they've allocated another place for Mr. Mahlangu. That the HOD of Human Settlement must within 90 days of this report give effect to the resolution to override the existing beneficiary approval in the name of the complainant in the Mamelodi Extension 17 site. So the complainant agreed to be allocated a service stand in ESDRS. The parties agreed that the settlement agreement constitute full and final settlement of the matter and the remedial action of the pipe protector. On human resource matters, we investigated an allegation of maladministration and improper conduct by the Independent Development Trust in the suspension and discharge from service of Ms. Lulu Bemba. Ms. Bemba lodged the complaint with my office in 2012. This is one of the oldest matters which we have. The 61-year-old is the former General Manager Legal Services at the IDT. In the main, she alleged that she was suspended from her position under the pretext of trumped-up charges, which were orchestrated for purposes of removing her from the position. She alleged that without any investigation being conducted, she was formally charged and subjected to a disciplinary hearing. And the IDT failed to set down her application for appeal against the disciplinary findings, where they then unilaterally terminated her employment. Upon analysis of the complaint, I decided to investigate whether IDT improperly or unlawfully suspended and discharged Ms. Bemba from IDT. Having considered the evidence uncovered during the investigation and against a relevant regulatory framework, I found that all the allegations above have been substantiated. On evidence uncovered, Ms. Bemba's supervisor, Ms. Pinky Maisela, had neither been requested to conduct an investigation into the alleged offences perpetrated by Ms. Bemba per the policies of IDT. So in this particular instance, we are checking the policies, what do they provide, whether the IDT followed those processes. I also found that Ms. Bemba was improperly prejudiced by the IDT's conduct under the circumstances. So in this case, we were purely focusing on maladministration. We were not focusing on what transpired at the labor, at the CCMA or the labor court. In the light of the findings, I direct that the Minister of Public Works to, within 30 days of receipt of this report, reprimand the chairperson of the board of IDT, Mr. Muzwaledi, and the chief executive officer of the IDT, Mr. Pagade, for failing to appear before me when I directed them by a subpoena to do so, and for failing to provide subpoenaed records which would have serviced to assist me in my investigation. The CEO of the IDT must, within 30 days, working days of receipt of this report, issue an apology to Ms. Bemba in the manner in which the suspension and the process was followed. Payment of service providers. Mukwena and Northwest Provincial Government, I investigated allegations of refusal and or undue delay by the Northwest Provincial Government to pay for services rendered between April and August 2010 by Mr. Mukwena, who lodged a complaint with my office in 2018 over alleged outstanding payment of 1.2 million. Mr. Mukwena alleged that he rendered services on 3 different occasions to the Northwest Provincial Government. The services involved provision of direction and advertising blimps, mobile advertising billboards, removal of banners, and exhibition boards. The alleged services were rendered during the 2010 Freedom Day, and also at the cost of 319,000, and in May, Mabatu Stadium, during the ZCC mass prayer meeting, that was 626,000, and 9 August 2010 during the Women's Day celebration, which is 278,000. So the complainant alleged that he had engaged officials, but with no success. I mean, it was also during the time when the current speaker was the premier of the province. He even engaged the current premier, and nothing was forthcoming. He even went to the Northwest High Court, the Public Service Commission, the Presidency Scopa, the Northwest Police. However, the Northwest Provincial Government remained unyielding when it comes to effecting payment. So those are the challenges which the small SMMEs are facing. Upon analysis of the complaint, I decided to investigate whether the Northwest Provincial Government unduly failed to pay Mr. Mukwena the amount alleged owed to him, and whether the conduct amounted to improper conduct and in terms of the Constitution, and maladministration in terms of the Public Protector Act. I found both allegations substantiated, and to remedy this, the Premier should write a letter of apology to Mr. Mukwena for the prejudice caused to him and his family, and the Premier must further ensure that Mr. Mukwena received a payment to an amount of 905,000 with interest calculated in terms of the prescribed rate interest of 1976 from date of the last invoice submitted by the complainant. This must happen within 60 days. So this is the impact which maladministration has on small businesses. Home Affairs matters, there's a Ramazan matter versus the Home Affairs. This was investigated. It's an improper conduct against the Department of Home Affairs following a complaint by Mr. Ramazani. The complaint, which was lodged in 2014, was that the department improperly adjudicated the complainant's permanent residence permit application, which is dated in September 2011. The subsequent written representations relating to the applications. Following a thorough analysis of the complaint, we decided to investigate 3 matters: whether there was an undue delay to adjudicate the complainant's permanent residence permit, and whether even after the written representations relating to the application, and whether that amounted to maladministration. Secondly, I investigated whether the department irregularly and properly adjudicated upon this application or the permanent residence application, and whether the complainant was improperly prejudiced. I found all of the above to be substantiated, and further, had the department properly and without delay adjudicated the complainant's PRP application, she would have qualified to apply for naturalization during 2017, thereby enjoying the full rights which are applicable to South African citizens besides the right to vote. The conduct of the department in this regard amounts to improper prejudice, which we've found, and to remedy the situation of improper prejudice and improper conduct, I directed the acting Director General of the department to ensure that the error in the complainant's permanent residence permit is rectified, and to apologize in writing to the complainant. This is meant to happen within 30 working days. On mining matters, there's a Tobane versus Department of Mineral Resources. I investigated allegations of failure by the Department of Mineral Resources to act against mining entities and related businesses whom were allegedly involved in illegal mining and other activities in Harte PS Fontaine farm in Steelfontein Northwest. The complaint was lodged in August 2011 by Mr. Tobane, who owns portion 37 of the farm. In the original complaint, he disputed and challenged the validity and lawfulness of the mining operations on his farm based on primarily non-compliance with the requirements and conditions of the mining licenses and rights granted by DMR. He also complained about non-compliance with and contravention of the Mineral and Petroleum Resources Development Act by a certain mining company or more, and lack of enforcement by DMR. The essence of the complaint initially raised against DMR was that it failed to monitor and enforce compliance with the obligations of the mining companies in terms of the relevant legislation. I found that DMR continuously failed to properly and diligently attend to complainants' allegations, and also to deal with the Buffelsfontein gold mine, which is illegally occupying his property and conducting mining and related activities without the legal right to do so, or not following proper legislative procedures. I also found that DMR failed to diligently execute its statutory duties and obligations to intervene in or take action in respect of the demolition of the hostel which was in that property by BGM without any conference or consultation with the landowner. I further found that DMR failed to diligently execute its statutory duties and obligations to intervene or take action in respect of a dispute between the complainant and this company BGM regarding compensation owed to the complainant as the landowner. In addition, another finding relates to the department failing to attend to complaints and allegations by the complainant that BGM had entered into agreement with 2 other companies to work in the mine dams on the property for the production and sale of sand and stone and the manufacturing of concrete blocks and paving dams on the property to produce and sell sand. So this was another finding. Another finding relates to the department failed to ensure that this BGM gave effect to the objectives of the integrated environmental management laid down in the relevant legislation, which is the National Environmental Management Act. To remedy this maladministration and improper conduct, the DG of DMR must, within 60 working days of this report, review and correct its records and any mining rights and surface permits registered against the complainant's property at the Mining Titles Registration Office to reflect the position as considered to, namely that the property was not the subject of any order right held by BGM under mining license or any converted new order mining. Within the same period, the DG must review the closure and rehabilitation process embarked upon by BGM since 2013 to distinguish between the properties covered under the order mining right under the mining license, as well as those properties that were not subject to such rights, on which it continued to conduct mining and related operation. So the DMR and the Minister of Mineral Resources within 90 days report the steps which they will be taking to independently assess and review the environmental liability of BGM, which was drastically reduced from the determined shortfall of 226 million in 2012 to 8 million in BGM's 2014 application for an amended environmental impact assessment. They must ensure that the environmental liability of this company, BGM, SEMA and JEC, is corrected before any closure certificates are issued in terms of Section 43 of the relevant legislation. The DG, in consultation with Environmental Affairs counterpart, must ensure that takes steps within 60 days again to deal with operations and activities on the complainant's property conducted without the approval of the relevant legislation. And the DG, in consultation with Water Affairs, again counterpart within the same period, in respect of the activities of the complainant's property conducted without the required water license, because they were supposed to have water license, but that was not the case as well. And further, this report, the DG must take steps to improve and encourage public participation in the monitoring of one environmental system to establish effective mechanisms to deal with complainants' grievance mechanisms, because they delayed so much to resolve this matter, which is in violation of Section 195 of the Constitution. The next matter relates to procurement irregularities. There's Vuna Health Logistics versus Mpumalanga Health Department. I investigated allegations of irregular procurement and fruitless expenditure by the Mpumalanga Department of Education of Health, following a complaint from Vuna Healthcare Logistics, who were one of the service providers that submitted a bid to the department for a tender. Essentially, Vuna alleged that the department awarded a tender for the management of warehousing, procurement and distribution of pharmaceutical and surgical sundries to Safamex on the 10th of September 2010, a bidder that was neither the highest ranking nor offered the best price. According to the complainant, Amalgamated Logistics in Mpumalanga had achieved higher scores on the department's scoring system and a lower price than that offered by Safamex. The complainant alleged that shortly after the award of the tender, Amalgamated Logistics launched an agent court application in which it sought to interdict the department from implementing the bid until the outcome of the review application. An interim court order was granted, in terms of which the department was interdicted from appointing Safamex and ordered to re-adjudicate the tender. It is alleged that the department persisted in implementing the services of Safamex, but on a month-to-month basis, despite the court judgment. This prompted Amalgamated Logistics to lodge a second agent application to interdict the department from utilizing the services of Safamex. on a month-to-month basis. But then this application also was successful. The implementation of this order was suspended by an appeal by SAFAMEX. However, the department has taken no further steps to challenge the appeal, and accordingly SAFAMEX continued to render services to the department. It was the complainant's contention that the department incurred fruitless expenditure by pursuing unnecessary litigation, irregularly appointing SAFAMEX for the same tender in 2015, and that the appointment is surrounded by suspicions of corruption, as it seems that officially the department has had vested interest in SAFAMEX. I investigated only for 4 issues from these allegations. We investigated whether the department irregularly appointed SAFAMEX on a month-to-month contract basis to render management of warehousing, procurement, and distribution. In 2012, second, I investigated whether the department incurred fruitless and wasteful expenditure by continuing to litigate on the matter. Thirdly, I investigated whether the department irregularly awarded the tender for the management of this for this tender. And lastly, I investigated whether Amalgamated Logistics Mpumalanga, Vuna Health Logistics, the taxpayer and other bidders suffered prejudice as a result of the conduct of the department. I found all of the above to be substantiated. Then for remedial action, the Director General of Mpumalanga Provincial Government must within 60 days of this report ensure that an investigation into regular expenditure is conducted and appropriate disciplinary steps are taken against the implicated officials. The DG must within 30 days ensure that the department declares the irregular expenditure in the financial statements to the provincial treasury, and within the same period of the finalization of the investigation, ensure that the matter is referred to DPCI and Asset Forfeiture Unit in terms of the relevant provisions of the Private Protector Act. The DPCI and AFU must investigate any alleged criminal conduct against implicated parties for financial mismanagement in violation of the Public Finance Management Act, especially the litigation costs incurred by the department and the irregular extension of the month-to-month contract to SAFAMEX. They must recover through litigation, civil litigation, any amount incurred as wasteful and fruitless expenditure from the former and incumbent HODs. The matter of Daniels versus Finance and Accounting Services Sector, which is and Training Authority, we'll call it FACET. I investigated allegations of maladministration, improper conduct, irregular expenditure in connection with the appointment of Guaranteed Trust Corporate Support Services to provide the services on behalf of FACET. The investigation originated from a complaint lodged by Mr. Ongeso of Chiseve Gwina Rachimbilani Incorporated Attorneys on behalf of the chairperson of the board. Mr. Daniels based his complaint on the findings and recommendations made by the Ligwa Advisory Services Forensic Investigation following an investigation into allegations of possible irregular expenditure in awarding the contract to this GTCSS from 2005 to 2016. In his complaint, Mr. Daniels requested that an investigation be instituted with a view to determining whether there were any irregularities in the award of in the procurement of the services, whether this company was unlawfully enriched as a consequence of maladministration on the part of senior officials of FACET, and based on analysis of the complaint, the allegation contained therein, I decided to investigate, and the findings were that they were substantiated in that the extension of the contract which was awarded to this GTCSS to provide the services and which would lead to placement in employment or learnership and internship is substantiated. As part of the remedial action, I directed the Minister of Higher Education, Science and Technology to take cognizance of this report, and also with the view of ensuring that the accounting authority of this faceta considers the acts of maladministration and improper conduct referred to it, and to avoid further occurrences. The Minister should include in his oversight role over the setters, in particular facet, the monitoring of implementation of remedial actions which have been taken in terms of this report. The Accounting Authority of facet must take cognizance of the findings and ensure that such conduct is not repeated, and take corrective and preventative action. Should consider evaluating the effectiveness of facet's internal controls on supply chain management processes to identify deficiencies with a view to take corrective action. The Chief Executive Officer of facet should take cognizance of the findings and also must of the maladministration and improper conduct by the former CEO, and ensure that such action is not repeated. The CEO must consider strengthening the supply chain management control environment by appointing suitably skilled and qualified head of supply chain management unit. And further, the CEO must focus on preventing irregular expenditure and non-compliance, and implement the supply chain management compliance checklist to supplement policies and procedures. In addition, the CEO must make a follow-up with National Treasury on application for condonation in connection with the identified financial misconduct, and take steps in connection with such financial misconduct as contemplated in the Public Finance Management Act. The next report relates to Anonymous versus Media Information and Communication Technology Sector Education and Training Authority. These are investigated allegations that the former CEO of this sector, Mr. Opa Mopaki, engaged in acts of improper conduct, corruption, conflict of interest, and irregular appointment of employees, and financially benefited from this sector through various companies that are alleged or linked to him. 2 anonymous complaints were received in this regard in September 2017. After analyzing the complaints, Mr. Mopaki, which included against Mr. Mopaki, which included the alleged conduct of some senior managers within the sector, I decided to look into 4 issues. Firstly, I investigated whether Mr. Mopaki personally aligned or linked to the private companies that are contracted to the institution, and whether, if so, that amounted to conflict of interest. Second, I investigated whether the sector, in particular Mr. Mopaki, irregularly appointed Ms. Sibanze to position of manager and senior manager, corporate services, in violation of their recruitment and selection policy. Third, I investigated whether Jabu Sibego, the senior manager learning programs, and Mr. Enes, the manager learning program, improperly aided Mr. Mopaki to siphon off the funds of the sector to private companies linked to him. Lastly, I investigated whether the conduct of Mr. Mopaki resulted in prejudice to the sector or any other person. I found all of the allegations which relates to the appointment of the private companies linked to Mr. Mopaki to be substantiated. As a remedy, I directed the current CEO to take appropriate steps to ensure that the report is implemented within 60 days, and they report all these irregular expenditures which have been incurred to the National Treasury and the Auditor General in connection with the irregular appointment of Mr. Sibanze to both position of manager and senior manager corporate services. Within the same period, the CEO must disclose all irregular expenditure incurred to National Treasury and the Auditor General. This is in connection with this irregular procurement which were conducted, and the procurement of Lila Corp, Network Infraco, and Bandwidth Technologies. These companies are the companies which are alleged to be aligned to Mr. Mopaki, and he never declared any relationship with them, and we made a finding that there was a conflict of interest. that within 30 days the CEO must take appropriate steps to ensure that all the officials in the procurement section are trained, and as well the officials in the HR are trained on their recruitment and selection processes, or even the policies. That the setter must within 60 days from date of this report develop a policy relating to the declaration of conflict of interest, because they don't have a policy as well which prevents staff from conducting business with companies which are awarded contracts with the setter. Lastly, DPCI must within 30 days from the date of this report consider initiating an investigation into a link and possible money laundering between Mr. Mupaki and the companies which were contracted by the setter. The other investigations we've conducted relates to irregular appointment of staff. There's a matter of Finger versus Mkawu. In this particular matter, Mr. Mkawu lodged a complaint of maladministration against the Mkawu district municipality. In fact, it was Mr. Finger who lodged the complaint. It pertained to the appointment of one Ms. Matsimo, a unit manager special projects, in September 2016. Upon analysis of the complaint, the two issues were investigated: whether the appointment complied to their recruitment policies. The second one, whether the appointment was improper and constituted maladministration. Following a thorough investigation, we found that these complaints were substantiated, and therefore we directed the municipal manager to take appropriate steps to discipline all the officials who were involved in the appointment of Ms. Matsimo. I also directed the municipal manager within 30 days within the 30 days of the report to review the recruitment policy of the municipality. Further, the municipal manager was directed to train the staff on the recruitment policy, and he must also conduct an analysis and evaluation of Ms. Mutsimo's qualifications, experience, competence against the requirements of the job. He must further submit a decision on the matter to council within 30 days of this report, and the executive mayor of Davi Grela municipality, where the former municipal manager is employed, under the same title of the outcome of this investigation, to take appropriate step against this municipal manager. The municipal manager must also institute proceedings for judicial review of the irregular appointment of Ms. Matsimo in terms of the Promotion of Administrative Justice Act within 30 days of this report, and the council must consider the reviewed policy referred to above and take a resolution on its adoption within 60 days. Van Roy versus George local municipality. This also relates to irregular appointment, a complaint which was lodged with the office, our office in George. It pertained to the appointment of the manager, sewer network, Mr. Van Staden. In 2017, the complaint was lodged by Mr. Van Roy in March 2017. On analysis of the complaint, we've discovered that indeed the appointment was irregular, and that the complaint was substantiated. The appointment of Mr. Van Staden didn't comply with municipal policies, and it was irregular. This makes the appointment again improper by the municipality and in violation of the Constitution and maladministration as contemplated in terms of the Public Protector Act. To remedy this, the conduct and maladministration, I have directed the executive mayor of the municipality to take appropriate step in respect of disciplinary action against the municipal manager and the other officials involved in the appointment of Mr. Van Staden. And the executive mayor must further conduct an analysis and evaluation of Mr. Van Staden's qualification, experience, and competence against the requirement of the job. This must also happen within 30 days and must also report this to council. After doing that, the executive mayor should institute proceedings for judicial review of the irregular appointment of Mr. Van Staden within 30 days, and the mayor must submit a report to council of whatever review which they've done, considering that Mr. Van Staden was not meeting the requirements for the position. Anonymous complaint versus Department of Education, again, is another irregular appointment where the complainant alleged that there's maladministration, mismanagement of funds, irregular recruitment processes at schools in District 14 of the Gauteng Department of Education. This complaint was lodged in September 2016. On analysis of the complaint, I decided to investigate whether the Gauteng Department of Education officials mismanaged the school fees at the Winnie Mandela Primary School in contravention of the applicable legal prescripts, and whether Ms. Mkhize, the principal of the school, improperly failed to hold the annual general meetings and prepare budget for the financial year 2015-16 at the school in contravention of the applicable prescripts. I also investigated whether the director, Johannesburg Central District 14, irregularly delegated her secretary to oversee renovations of the school, which was alleged to cost 800 million. And further, whether the appointment of the following officials, Mr. Molefe, Mr. Mabuza, Mr. Mkhize, Mr. Biela, and Mr. Nemukula, followed the process. Lastly, I looked into whether the complainant or taxpayer or the department suffered any prejudice because of this conduct. Having considered all this, and whether these are in violation of the relevant prescripts, I found that the complaints are substantiated. However, the allegation that Ms. Mkhize improperly failed to hold the AGMs and prepare budget for the financial year is not substantiated. So is the allegation that Ms. Sieta delegated her secretary to oversee renovations of the school at the cost of 800 million. So those were not substantiated. When it comes to irregular appointments, I found the allegations relating to only 2 of the 5 officials who were alleged to have been irregularly appointed substantiated. This is the appointment of Mr. Molefe and Mr. Mabuza. The rest were fine. As part of the remedial action, I directed the HOD, Gauteng Department of Education, to take appropriate steps to ensure that it takes disciplinary action against the implicated employees who were involved, and within the same period initiate a judicial review process to set aside the appointment of Mr. Mabuza and Mr. Molefe, and also within the same period the HOD must initiate a judicial review, in fact for both Mr. Molefe and Mr. Mabuza, to set aside. The HOD must further disclose all irregular expenditure to the Provincial Treasury and the Auditor General incurred by the Gauteng Department of Education. Anonymous versus Mpumalanga Department of Education, we investigated this. Also is still recruitment irregularities, which is very prevalent in most of the provinces. This was a complaint. It was an anonymous complaint which was received in 2015. It was based on a City Press article of September 2015. The article in question alleged that the departmental authorities lowered the requirements of a director's post in the Department of Basic Education to suit the newly elected Deputy President of the ANC Youth League, Desmond Muyela. The department had advertised the post according to the newspaper in a circular in July, in which it was stated that the educational requirements for the post were appropriate, a recognized bachelor's degree, a diploma or grade 12 plus extensive appropriate experience. According to the newspaper, the investigation had, however, found Muyela's attempt for a 3-year qualification at the Tshwane University of Technology in 2009, where he failed all 3 subjects he registered for. The newspaper claimed that he eventually dropped out, so he failed to achieve that qualification. On analysis of the complaint, we decided to investigate whether the department improperly and irregularly lowered the requirements of the position, which is Director Human Resource Capacity and Development, to suit Mr. Muyela. Second, whether the department failed to follow proper recruitment and selection process. These allegations were found to be substantiated, and in addition, we requested then the department to take or to implement the following remedial action. That within 30 days from date of this report, the job description of the position in question is reviewed, and that the required minimum qualifications are aligned with the guidelines of the appointment of senior manager in the public service. The HOD must, within 60 days, ensure that the Chief Financial Officer investigate the fruitless and wasteful expenditure incurred and report it to the Provincial Treasury. And the HOD must also, further within 60 days, take appropriate steps against the employees implicated. And also the HOD must institute a judicial review to set aside the appointment of Mr. Muyela. I look forward to the full implementation of the remedial action in all these reports. In the event the organ of state affected wish to get clarity from me as regards the findings and remedial actions, my door remains open to engage. We need to move to a point where we save public money and stop being unnecessarily litigious. In the matter of Njongi versus member of the Executive Council, Department of Welfare in the Eastern Cape, it's a constitutional court matter. The court held that when an organ of government invokes legal processes to impede the rightful claims of its citizens, it not only defies the Constitution, which commands all organs of state to be loyal to the Constitution and requires that the public administration be conducted on the basis that people's needs must be responded to. It also misuses the mechanisms of the law, which it is the responsibility of the courts to safeguard. The province's approach to these proceedings was contradictory, cynical, expedient, and obstructionist. It conducted the case as though it were at war with its own citizens. The findings and remedies in these reports are not about the public protector, but rather a way of bringing justice to complainants while also plugging gaps we see in state institutions, especially on the governance system, to avoid recurrence of whatever we've picked up. I plead with organs of state that we work together in that spirit. As I conclude, let me wish all people of South Africa a wonderful and safe holiday, as well as a prosperous 2020. For those who celebrate Christmas, may you have a merry one with loved ones. See you in the new year so we can work together to take the services of this institution to the grassroots.
Thank you, Public Protector. At this juncture, I will open the floor for questions on all of the findings and remedial actions that the Public Protector has reviewed this afternoon, but also on other matters that are related to the work of this institution. Let's see who is going to fire first. Two hands this side. Two hands this side, and then Mr. Ampiano is going to assist us with the roving mic there. Those are the two hands up at the stage. Let's start with them and then we'll have another round. Please introduce yourself and the media house you represent. Thank you.
Thank you so much, Advocate. It's Komodo Modise from Eyewitness News. I'm just looking at this on the third page of your statement. You referred to how the investigation with regards to DBS and the role of the Reserve Bank has been a challenge for your office. I just wanted clarity on the steps you've taken in order to get the Reserve Bank to cooperate. Can you elaborate just on these challenges that you're facing? Is it a matter of them not wanting to cooperate? are you going to be doing anything going further? What can you do as the office going further to ensure that there is cooperation on their part, and when can we then see this matter finalized?
Good afternoon. I'm Kalambati from Bloomberg News. Advocates, just following up on my colleague's question, there are a number of high-profile investigations that are underway. They've not been concluded yet. Can you give us an indication of when some of those reports may be finalized and possibly released to the public? And then my second question is, Parliament has finally concluded or come up with the rules which it will adhere to when it comes to the removal of anybody who sits as the head of a Chapter 9 institution, including your office. What do you think about this particular step that was
for him when he was deputy president, but also now as to how bad the scenario had